Let us talk about legal remedy in case of rejection of nomination of a candidate in the central or state legislature. To contest election, the candidates submit their nomination form along with the requisite documents to ascertain or to verify whether the candidate fulfills the requisite eligibility requirements or there is no fraud or misrepresentation on the part of the candidates. The nomination papers are scrutinized by the election officer on the date so fixed. The scrutiny is done in the presence of all the candidates who submitted their nomination before the cutoff date. The candidates are also allowed to submit their objections with regard to the nomination of a particular candidate. After considering the objections and on being satisfied with the entries made in the nomination form, the nominations are either accepted or rejected. The question arises, what is the legal remedy available to such a candidate whose nomination has been rejected? Dear friends, to ensure a free and fair election, provisions have been made in Part 15, Article 324 to 329 of the Constitution of India. Let us look to the constitutional provisions first. The Constitution provided for an election commission to ensure free and fair election. The provision has been made to ensure that there is no exclusion of a citizen from the electoral roll or voter list on the basis of religion, caste, race, or sex. It has been provided that the elections to the Lok Sabha and the Vidhan Sabha of the states would be conducted on the basis of universal adult suffrage, and nobody could be denied to be a voter on the basis of his religion, race, caste, and sex. The provision has been made to enable the legislature to make laws for the smooth conduct of elections. In Article 329 of the Constitution, the provision has been made that once the election process has started, disputes regarding election could be raised only by way of election petition. The details of the manner in which the election disputes could be raised and decided has been provided in the Representation of Peoples Act. Section 80 provides that election disputes relating to Parliament or to the State Legislature could be raised before the respective High Courts. Normally, it is heard by a learned single judge as authorized by the Honorable the Chief Justice. As per Section 100 of the Representation of Peoples Act, the election could be set aside, firstly, if the candidate was not able to fulfill the eligibility requirements. Secondly, if the candidate is found indulged in corrupt practices. Thirdly, if the nomination has been improperly rejected or accepted. Fourthly, if the invalid vote has been treated valid and the valid vote has been treated invalid. Therefore, looking to the constitutional and the statutory provisions, it appears that legal remedy against improper rejection of nomination is by way of filing a election petition before the High Court. So far as invoking extraordinary jurisdiction of the High Court under Article 226 of the Constitution is concerned, the rejection of a nomination by the election officer cannot be assailed in a writ petition for the reason that it has been categorically provided under Article 329 that any dispute pertaining to the election after the election process has started could be raised only by way of election petition. And this issue has been firmly and finally settled by the Honorable Supreme Court in the case of Mohinder Singh Gill versus Chief Election Commissioner, New Delhi, wherein it has been held that in view of the categorical provision of Article 329 of the Constitution and the statutory provisions of the Representation of People's Act, the grievance of improper rejection of nomination could not be raised under Article 226 of the Constitution of India. Therefore, in the totality of the circumstances, if there is an improper rejection of nomination, the same could be assailed in an election petition after the election process is over. Thank you.